What's up, everybody, and welcome to Chapter 3. This is Equal Employment Opportunity and Human Resource Management. You guys can take a look at the learning outcomes and so forth. Okay, so we're going to begin our journey with the EEOE, and that is Equal Employment Opportunity, and that is a fundamental principle to ensure that fairness in hiring, promotion, and workplace treatments. What it does is that guarantees employment decisions are made based on merit rather than the personal characteristics that are just unrelated to the job, okay? So we are trying to make sure that hiring is fair and it's not based on something that is a bias, whether conscious or unconscious. The Equal Employment Opportunity Commission, what it does is that it enforces laws that prevent workplace discrimination. And really, it doesn't create the laws themselves, but what it does is that it investigates claims of discrimination, it mediates disputes, and it provides guidance to businesses on compliance. Companies today, in today's world, really just have to navigate an increasingly complex landscape of the equal employment opportunity laws. And so a key aspect of compliance is ensuring that HR policies align with federal and state regulations. So companies have to educate employees, particularly managers, on anti-discrimination practices to prevent any legal consequences and really just foster this culture of fairness. All right. So some historical things is that, or the evolution of this equal opportunity employment laws in the United States have been gradual, and they reflect a shift in societal value and economic conditions. Historically, workplace discrimination was not just tolerated, it was actually more so institutionalized. So discriminatory hiring practices, wage gaps, and exclusionary policies were once the norm. That was what everybody knew. So for example, these were things that affected women, they affected minorities, and they affected other marginalized groups that would not be employed today had this shift not taking place. So while the US had made significant progress, workplace discrimination still exists. And there are certain implicit discrimination biases, wage gaps, and barriers to achieve, that we need to focus on or get through to advance the remaining stages so that their workplace discrimination is eliminated. Okay? So there are three factors that we're going to look at. One, the changing attitudes towards employment discrimination. So social movements, advocacy efforts, and shifting public sentiment have driven the changes in employment laws. As a society, kind of we've become more aware of systematic inequalities, things that would go under the radar because they were just seen as normal, are now being highlighted and flagged for equality purposes. The next thing that we have is published reports on economic injustices experienced by minority workers. And so data and research have highlighted discrepancies or disparities in wages, hiring practices, and job opportunities. And reports showing economic disadvantages faced by minorities have helped build the cases for stronger legislation. Now, so numbers, essentially, the idea is, okay, so this is not a one-off case. This is actually something that's documented and it could be proven. Not that they necessarily needed the proof, but more so it needed to build a case that this is not a one-time thing. And the last thing is a growing body of disparate discrimination laws that legislators seek to standardize. So over time, various states and municipalities implemented their own anti-discrimination laws, but then we have federal intervention, and that became necessary to ensure that there's at least a baseline of consistency and effectiveness in protecting workers nationwide. So the US has historically upheld ideals of meritocracy and equality. This has been something that the United States have done really, really good job at from the very beginning. But discrimination in employment has still persisted. And progress has been made, but there are ongoing debates about expansion and the protection, and there's always more of it. So you have the Employment Non-Discrimination Act, ENDA, which thought to extend federal employment protection to include sexual orientation and gender identity. In some states, they have implemented these already for on their own, but the federal law remains inconsistent, and that's something that needs to be worked on. What are the early stages of development? First and foremost, you have the Civil Rights Act in 1866, and this law aimed to ensure that all individuals, regardless of their race, had equal rights, but its enforcement was limited. So the law was there, but the enforcement was limited. Okay. Then you have Unemployment Relief Act, and this act aimed to prohibit employment discrimination based on race or religious beliefs. Okay, so race, color, or creed. And so that's kind of advanced it forward. And then you have Executive Order 8802 in 1941, where it ensured that every American citizen, regardless of their race, had employment opportunity post World War World War II, or during World War II. This essentially order sought to eliminate racial discrimination in defense industry hiring. So this is particularly for the defense industry, defense contract. All right, so unfortunately, these early efforts did not correct employment discrimination. They helped, right? They set the stage for it, but they did not completely correct it. Government intervention has played a critical role in ensuring workplace fairness. So laws and executive orders have evolved to address different aspects of discrimination, creating a framework that protects employees from unfair treatment. And one key reason why managers and supervisors have to understand the EEO laws is that organization can be held legally responsible for the violation. So if a manager discriminates against the employee, it's not just the manager who gets in trouble. It's actually the organization and the company as well that can face legal consequences. So organizations on their part, they really have to go and train people in order to train managers in order to make sure that this stuff doesn't happen and that they stay in the clear. Okay. Now, employment discrimination laws, they prohibit unfair treatments, such as hiring, firing, job advertisements, promotions and pay decisions, regulations against whistleblowers. And as guys can see, recruitment, testing, use of company facilities, all of these things, they are prohibited. They prohibit discrimination against employee practices within these areas. Okay. So laws address more, some laws, they address more subtle forms of discrimination, things like stereotyping and developing employment based on, denying employment based on association with protected groups. So organizations must recognize and prevent these practices to ensure compliance and fairness. So again, it's illegal in any aspect of the employment to discriminate in hiring and firing, compensation, all this stuff that is right there. So the EEO laws protect specific groups called protected classes from workplace discrimination. These are people that were seen as more of the minorities, people that could potentially be hurt by the biases that created. So I don't think it's like intentional. Yes, there are certain people that may not be great, but that's not what they're trying necessarily to protect against. Sometimes the majority of people are good, and it could be very well that they don't realize that they're biased, and they don't realize that their behavior is discriminatory. And so these are the classes. So you got race and class, religion, national origin, sex and gender, age, physical and mental disabilities. The diagram just represents these classes as well, as you can see them all right there. Okay, so understanding the legal frameworks that governs equal employment opportunity is critical for both the employers and the employee. Over the years, key legislation has shaped workplace policies aiming to eliminate discrimination and create a more equitable environment. The first and foremost, you've got, and you guys can go through all of them as well. We're just going to pick a few of them that we are looking at. The first one that you have is the Equal Pay Act of 1963, and it was a landmark law that sought to eliminate gender pay gaps, requiring employees to pay men and women equally for equal work. That may persist today, but that is the current law. Okay, the Title VII of the Civil Rights Act of 1964 is one of the most influential EEO laws prohibiting discrimination against race, color, religion, sex, or national origin. This law led to the establishment of the Equal Employment Opportunity Commission, which we talked about before, but we'll talk about it a little bit later. And then the Age Discrimination in Employment Act of 1967 protects workers over 40 from being unfairly treated due to age. You've got Pregnancy Discrimination Act again. These are protecting mothers, okay, or expecting mothers. You've got other critical laws such as Americans with Disabilities Act of 1990, the Civil Rights Act in 1991, and things continue to evolve. All right, so the bona fide occupational qualifications are exceptions that allow employers to consider specific characteristics such as age, religion, sex, or national origin when they are essential for a job. However, the bona fide occupational qualifications are highly scrutinized to prevent discriminatory practices that are disguised as job qualifications. So the idea is this. So age can be a bona fide occupational qualification in professionals like airplane pilots, where safety concerns justifies retirement age limit. Okay, so that is a must. Sometimes religious institutions may require employment in certain roles to adhere to faith traditions. For example, you don't have a Catholic priest who is, you can't hire a Catholic priest who is a woman, and you can't hire a Catholic priest who is not has not gone through the ordination process, right? So while the parish is technically hiring that parish priest, that priest needs to have those qualifications based on the religion and the tradition and the faith. Okay. However, not all employee preferences qualify for this. So for example, a company cannot refuse to hire a woman for a sales position because they believe men are more attractive to customers. Okay, so if customers prefer male salespeople, they cannot hire based on that. Okay, so it has to be truly necessary to perform the job. That is what bona fide occupational qualifications are. All right, so some things that Americans with the Disability Act suggestions for accessible workplace made sure that it happened. So easy to reach switches, providing sloping sidewalks and entrance. So the idea of this is to create and ensure accessibility for people with disabilities. So jobs and employers have to provide this. This is something that makes equal opportunity possible. For some of the people who have disabilities, there are certain things that they cannot do without this. So the employers have to provide these things, whether it's wheelchair ramps, wider doorways, accessible restrooms, flashing alarm lights, raised markings on control buttons. All of these, they help individuals that have disabilities navigate the workplace, and they are very needed. And employers should also consider job-specific accommodations, such as like work schedules or assistive technology for employment with cognitive disabilities, and so forth. The idea is to go beyond the legal compliance to foster employees by creating a diverse, innovative, and collaborative workspace. And you could go through this list and you guys can see it as well. All right, executive orders, they play a crucial role in expanding the EEO protection, particularly in individuals working with government contracts. So since the federal government often involves public funds, the government imposes stricter anti-discrimination policies on these employers. So for example, Executive Order 11246 in 1965 prohibits discrimination in companies with government contracts exceeding $10,000. And that is to ensure that taxpayer monies go to support fair hiring practices and that the taxpayers' money are not paid to someone who is not following these rules and regulations. All right, and so this is the one we cited earlier, but federal laws provide foundation for the EEO protections. However, state laws can take things into their own hands and they could push things a little bit further. So states and local governments often implement additional fair employment practices law, and these are important for small businesses that may not be covered under broader federal statutes. And so the Fair Employment Practices often address gaps in federal law, offering protection for groups that may not be fully covered under national policies. So, for example, some states prohibit discrimination based on sexual orientations or marital status, even though these categories are not explicitly included in the federal statutes. And so, what employers in operating in multiple states can do is be aware of these regulations and their differences. And typically, they should adopt a universal EEO policy that exceeds the legal requirement that really just focused on creating a workplace culture that values fairness and inclusivity regardless of the location. So it's not about the where they're at, but really just go deeper into it to actually include other things as well. These are some of the executive orders that you can look at through federal contracts and agencies. That's what we were talking about, and this is the fairness employment practice that we just mentioned. All right. So federal laws and executive orders, they have a lot of challenges, and that includes sexual harassment, sexual orientation, and immigration reform and control. We will look at each one individually in a second. Now, the sexual harassment is probably one of the most damaging forms of workplace misconduct, filing under two primary categories: the quid pro quo harassment. And this occurs when employment decisions are conditioned on an employee's acceptance or rejections of sexual advances. And so, are there going to be tangible or economic consequences like a demotion or loss of pay or a promotion if that person says yes to those sexual advances, or they say no to them, and that's what they need to know. So, and the other thing is hostile work environment. So, inappropriate behavior creates an intimidating and offensive workplace. So, occurs when unwelcome sexual contact has the purpose of effect of unreasonably interfering with job performance or creating an intimidating, hostile, or offensive workforce environment. Sorry. The next one we have is the sexual orientation. While federal laws does not explicitly prohibit employment discrimination based on sexual orientation, protection of the LGBTQ plus employees often come from state or local laws. However, the Equal Opportunity Commission interprets the Title VII prohibition on sex discrimination as also applying to cases involving sexual orientation and gender identity. So it may not be explicitly stated, but it is considered under these categories. And you can see some of the things that are listed there. So firing or hiring an applicant because she is a transgender woman, denying employee equal access to common restrooms, denying an employee a promotion because of sexual orientation, harassing an employee because of his or her sexual orientation. These are all things that the EEOC interprets and enforces as well, regardless of where they are. So if you look at it state by state, you can see this map shows the ones that have laws that prohibit both. And you have states that do not, and you have quite a few states with no laws in place, and so forth. So you can kind of see this mosaic of pieces where you can see really just the effect of the local government and what the local government does and how it interacts with it. And you can see even by states themselves, if you take a look at Arizona, I want to say there's a portion of it that has the sexual orientation in public employment, and then there's a portion of it just has laws that prohibit both, which is it's quite interesting to see. And then the last one we have is employers must the Immigration Reform and Control Act. And this is Immigration Reform and Control Act. It plays a crucial role in ensuring that workplace hires individuals who are legally authorized to work in the United States. And the law is divided into two provisions. One, first, it prohibits employment of unauthorized individuals, and second, it protects discrimination based on citizenship or national origins. So employers are required to complete I-9 forms for every employee, verifying their identity and work authorization. And they actually have to do this, but they cannot have something called a document abuse. So, for example, demanding more documents from foreign-born employees than required by law is discrimination. Okay. They also cannot discriminate based on immigration status is also prohibited. So employees cannot refuse to hire individuals simply because they are non-citizens if they are legally authorized to work in the United States. Okay. Additional emerging issues that are there, weight discrimination. So based on weight, sometimes women in particular face biases in hiring and promotion. So some states and localities, such as Michigan and San Francisco, have enacted laws prohibiting weight discriminations, but it really just remains legal in most parts of the states. And employers should ensure that hiring and promotion decisions are not based on attractiveness, but they are appearance, but they are based on merit. The second one is attractiveness and discrimination. Now, beauty is in the eye of the beholder, so these are a little bit harder to track, but it is known that people who are more attractive get more opportunity. Conventionally attractive, right? What is Hollywood-like attractive, I would say. Okay, what is the common um, benchmark for attractiveness? And that is that gives them more opportunities, but that's not always trackable. And caregiver discrimination, so affects employees who have significant caregiving responsibilities, so parents or people who are caring for elderly families. Some employers hesitate to hire or promote employees that they perceive as unable to commit fully due to caregiving duties. And that would fall under the Discrimination in the Family and Medical Leave Act as well. Okay. The Uniform Guidelines on Employee Selection Procedures, as published in the Federal Registrar, provides a framework to help employers avoid discriminatory hiring practices. Now, these guidelines, they ensure that employment tests, interviews, and other selections instruments, they comply with the Title VII of the Civil Rights Act. That means that they must not disproportionately disadvantage any protected class without a job-related reason. There has to be a reason why they are administering the test. So, for example, we're going to go through validity. Validity first is essentially the employers has to demonstrate that the test or selection tool directly relates to a job performance. Okay. If a company uses aptitude tests, for example, it must show that a higher score on the test predicts success in the role. The validation process is essential, as failing to establish the test's relevance can expose the company to discrimination laws under the disparate impact law. The next ones that we have is adverse impact, which occurs when hiring or promoting processes disproportionately excludes a member of a protected class. This is a well-known rule to measure the impact, and it's called the 4/5 rule, which states that if the selection rate of any racial, ethnic, or gender group is less than 80% of the selection rate of the most favored group, an adverse impact is presumed. So employees must then either justify the selection process as necessary for a business operation or modify it to reduce bias. And desperate treatment is the last one, and that is It differs a little bit from the adverse impact, and it is intentional discrimination. So adverse impact is unintentional. Disparate impact is intentional. So such as hiring men for technical roles, but rejecting equally qualified women. And key word here is equally qualified women. All right. So you're rejecting them simply because they are women, not because you know that they are unqualified. And the law prohibits both discriminations. So. And this is the 4/5 rule. And it's a rule of thumb, again, that the EOC follows in determining adverse impact. And a select program has an adverse impact when the selection rate of any racial, ethnic, and sex class is less than 80% of the rate of the class with the highest selection. Okay, so that's essentially saying the same thing we just talked about. All right, next up we have the, one second. The work utilization analysis, which compare the company's employee demographics to surrounding labor market, and it helps ensure diversity goals are met. And the key takeaway here is that organization not only should avoid explicit discrimination, but also proactively eliminate subtle systematic barriers to fair employment. So the idea is to kind of keep on going with analysis to make sure that there's nothing that is missing. In the Equal Opportunity Commission, that is a federal agency responsible for ensuring workplace fairness, as we've mentioned before. And here again, we're looking at discrimination based on race, age, gender, disability, religion, and more things. And it does two things. One, it establishes guidelines and monitors workplace compliance. And two, it investigates and persecutes discrimination claims. So what happens is when an employee believes that they have faced discrimination, they may file a charge of discrimination with the EEOC. This triggers an investigation to determine whether the claim has merit. Now, employees must maintain accurate records and comply with posting requirements to inform employees of their rights. Employees have the right to know that they can file a claim with the EEOC. Failure to do so can result in fines, lawsuits, and reputation damage. Moreover, willfully falsifying records or obscuring the EEOC investigation can lead to criminal charges. So transparency and adherence to the EEOC policies not only protect businesses from legal liabilities, but also fosters an ethical workplace culture. The other thing that we want to look at is retaliation. And retaliation is the most significant risk companies face because employees who file the EEOC complaints are legally protected from retaliatory actions. So things like demotions, pay cuts, or terminations. Managers really have to be trained to handle complaints neutrally. And that ensures that employees feel safe and report discrimination without fear of reprisal. And so ultimately, the businesses that actively enforce the equal employment laws benefit from diverse, high-performing workforce, and organizations should just really integrate bias-free policies, continuously train and open dialogue to uphold fair employment standards, and really just prevent the legal challenges. Okay. So, one second, my good people. Preventing discrimination before it occurs is actually far more effective than dealing with a lawsuit after the fact. And so the foundation of a discrimination-free workplace is strong, well-communicated, equal employment opportunity policy. The better your policy is, the more likely you are to prevent a lawsuit. And you don't want to deal with a lawsuit. You want to be able to do this from way before. So a comprehensive policy must not only comply with legal requirement, but also clearly define discriminatory behavior. They should provide real-world examples and set out a transparent process for reporting and addressing complaints. They have to be Very clear cut. This is right, this is wrong. Okay. A challenge in implementing such a policy is ensuring that it's not just a document that sits in the HR folder, sorry, and employers really have to be actively disseminating, there we go, the policy and integrating it into the company culture. Now, this means conducting regular trainings, maybe sessions for employees, maybe specifically focusing on managers and supervisors who are responsible for enforcing these policies in day-to-day operations. The best way to prevent discrimination is to build an inclusive organizational culture. And that's essentially what you want to do. Affirmative action policies go beyond the Equal Opportunities Law by requiring organizations, particularly those with federal contracts, to take a proactive step in increasing workplace diversity. And so the policies, they aim to correct historical inequalities and expand opportunities for women, for racial minorities, and for other underrepresented groups. And while these affirmative action programs can enhance diversity and innovation, they can sometimes create be controversial due to the concerns of something called a reversal or reverse discrimination. And that is essentially where there is a preference in hiring for protected groups, disadvantages others, but that is generally uh, uh, not the case. And so the courts have generally upheld the affirmative action policies and a policy that goes again beyond the opportunity by requiring organizations to comply with the laws and correct the past discrimination, which is essentially what we said earlier, and really just do remedial measures rather than rigid quotas, as opposed to like this is a quota that we have to reach. So organizations that adopt diversity management strategies often improve their employee morale, productivity, and brand reputation. The role of the Chief Diversity Officer has emerged in recent years to really just help the companies integrate inclusive hiring, training, and promotion policies. So, one of the most effective frameworks for diversity management is the leverage difference model. And this is what you will see now. And the leverage difference models is essentially recognizing that employees come from diverse backgrounds and that is with different perspectives, and that's something really cool and good, and it's wholesome. So once you recognize that, then you want to value the difference. That's step two, and that fosters an organizational culture where the differences are appreciated, not merely tolerated. And then the third step is leveraging that difference, using diversity perspective to drive innovation, problem solving, and business growth. And then the cycle continues, and you want to keep doing this over and over again. So diversity should not be seen really as a compliance obligation, but as a competitive advantage. So companies that invest in inclusive hiring, cultural competency trainings, and mentorship programs positions themselves as leaders in the modern workforce. All right, my friends, that is it for today. Thank you so much for listening. If you have any questions, please let me know. I am here to help you in any way that I can, and I will be with you next time.